Good evening and welcome to tonight's special Connecticut Mirror event with Supreme Court reporter and analyst extraordinaire Linda Greenhouse. We'll be talking about this momentous court term, and we'll be taking some of your questions in just a bit. More on that in just a while. I'm John Dankosky. I host events here at the Connecticut Mirror and also podcasts. You can check out our most recent podcast that I did with Mercy Quay anywhere you find your podcasts. We would like to extend a special welcome to guests joining us tonight from other statewide nonprofit news publications: Spotlight PA, Mississippi Today, New Jersey Spotlight, and Vermont Digger. Thank you all so much for joining us. The Mirror has hosted more than 24 virtual events since the onset of the pandemic, but tonight's is far and away the largest of these events, and we're thrilled to have our partners from around the country joining us. Tonight's event comes on the heels of an announcement yesterday that the Mirror has hired a new federal policy reporter, a new justice reporter, and a new general assignment reporter. It's all part of a big hiring wave that's the largest in the organization's history. Just take a moment to let that soak in. You're hearing an awful lot about other publications, for-profit publications around the country whose newsrooms are shrinking. Here at the Connecticut Mirror, we're growing. And so to all of our members here tonight who made this possible, thank you for joining in the work of the Connecticut Mirror through your financial support. To our readers who haven't yet given or would like to give at some point, you can consider making a tax-deductible gift through our very easy portal. You can go to our website, ctmirror.org, and click on the big red button at the top of the page. With this additional funding, we hope to hire a new data reporter, a third editor, because you need more editors if you have more reporters, and also more folks to the team later this year. So thanks to everyone who's given. Thank you to you if you've considered making a gift to the Connecticut Mirror. We'll be making some links to the Mirror available in our chat for tonight's event, and also other links as we go along, some links to Linda's reporting. Thanks to our friend Kyle Constable at the Connecticut Mirror for producing this. You can have a dialogue in the chat at the bottom of the page with others who are part of this. But if you want to ask a question of Linda, please use the Q&A function at the bottom of your Zoom page. That way I will see the question and I'll get to as many of them as I can. We already had some questions come in advance and we've got some tonight. So I want to make sure I get to as many as we can. Please go to the Q&A function if possible. Linda Greenhouse is a Pulitzer Prize-winning reporter and essayist who's been covering the court for decades. And each year at this time, for the last few years, she's joined us to discuss the past, the present, and the future of the Supreme Court. So Linda, welcome back. Thank you so much for doing this for our Mirror readers and for all the readers across the country.
Happy to be here, John. I'm a loyal CT Mirror reader myself.
Well, we always appreciate you not only reading and supporting us, but also doing this for us. And boy, we've talked in the past at the end of important Supreme Court terms, but I don't think that we've ever seen anything that's this consequential. Just dropping major announcements one after another on guns, on climate change, and of course on abortion rights. Before we get to these individual cases and what they mean to America right now, have you ever seen a term like this?
I've seen some pretty exciting terms, but I've never seen one that is so profoundly unsettling of the way modern American society is organized, with the assumption that women have reproductive freedom and as a matter of constitutional right. I've never seen anything like this.
When you use the word unsettling, it feels like it has a number of layers there. The layer I want to get at is just how much it stirs things up. The court seems to have written here in the majority that this somehow has now settled an issue that has for a long time been divisive in America. And it feels as though almost exactly the opposite thing has been done. It has been completely unsettled now. There is so much more to deal with because of this consequential ruling.
Well, absolutely. I mean, what we're seeing is chaos and misery. Now, Justice Alito, who wrote the majority opinion, tells us in his opinion that we don't actually care what people think. But, maybe some of them do. And chaos and misery, that about sums it up, I think.
Again, before we dig too deeply into this abortion case, what is different about the way that the court organized itself to take on these issues? You've talked with me in the past about the Roberts Court having particular plans or desires, things that they want to do. What happened this time that's different than what has happened in the past?
Right. So what we see is the working out of an agenda that's been there for all to see. We can't say we weren't warned. In fact, last summer at this time, I was finishing up a book project, and the book came out in November. This past November, it was a chronicle of the term of the court with the three Trump justices, the 2020-2021 term that ended a year ago, early July of 2021. And I talked about in that book the cases that the court had agreed to decide, the cases that they accepted. And what did they accept? They accepted the abortion case from Mississippi. They accepted the gun case from New York. They dealt around with a lot of voting rights issues. I mean, everything that happened this term really was forecast by the new dynamic when Amy Coney Barrett's nomination was rushed through as Americans by the millions were already casting their votes in the 2020 presidential election. And she gave us the super majority of, one might say, conservative, radical, pick your adjective, that we have on the court today, basically squeezing out Chief Justice Roberts, who seems like he was trying to keep a somewhat steady hand on things for the sake of the court's reputation and his own reputation, but he failed to be able to do that. So that's what we have. We have a court that can basically now do whatever it wants in service of its agenda, and there's nobody on the court or off the court who can stop them.
Looking back at the history of the Supreme Court, as you've covered it, there's always been a sense that there's ideology, that there is agenda. Has it ever been quite like this in terms of it being so pronounced, let's say?
Well, not in my time. I'm not going to say not in history. Of course, we know the great struggle between the very conservative Supreme Court of the 30s and FDR and that crisis. So, I don't want to say, oh my gosh, nothing like this has ever happened before. But when I first started writing about the court in the late 1970s and really through the 80s and through the 80s and 90s, what we took for granted about the court is that you couldn't look at the 9 justices and predict how things were going to go because of which president appointed them. And this is the first time, once Justice John Paul Stevens retired, and he had been Gerald Ford's only Supreme Court nominee, when he retired early in the Obama administration, we had for the first time a court where all the conservatives were named by Republican presidents, all the more or less liberals were named by Democratic presidents. And so the public can look at the court and say, what's that about? And so the projection of the conservative agenda onto a basically unwilling public, to the extent that the public has informed itself about this, is something that we haven't seen in, I don't want to make a guess about your age, John, but I would say in our lifetimes, we have not seen this.
The essay that you wrote in the wake of the abortion decision was titled, and understand that the writers of these pieces don't always get to write the headlines, but the headline was—
I wrote that headline. I wrote that.
The headline was Requiem for the Supreme Court. Those are strong words. Tell us more about what you mean.
Well, the first lines of that piece to which you're referring were, it was about the Dobbs opinion, the abortion opinion. They did it because they could, period, paragraph. It was as simple as that, period. Now, to be able to say that about a decision of the US Supreme Court to which I've devoted my professional life, studying and trying to understand, that really pulls down the curtain on the court that we knew. Because if you read the Dobbs opinion, and I certainly I encourage people always to read Supreme Court opinions, you'll see that it's a mishmash of little bits of asserted history, this and that. The two things it's not law, and it's not anything about women. Women are invisible in that opinion. And you're just left scratching your head, and there's no other explanation except that these 5 justices who joined that opinion did it because they wanted to and because they could, not because the Constitution told them to do it, not because the public told them to do it. We knew the public by 2 to 1 is quite upset about this. They did it because they could. And that's why I came up with Requiem for the Supreme Court, because the Supreme Court that we knew it is functionally over if this is the new reality.
Women are invisible in the opinion is without a doubt true. It also seems as though science is invisible in the opinion. And I guess I'm wondering, for those of you who know me, my other job is I work with Science Friday, a national talk show that devotes itself to conversations about science and the scientific method and talking with scientists about the work. And that is certainly what we've been hearing from people in the science community. There's not a whole lot of science in here. Does it strike you in any particular way, Linda, that you could have an opinion that is so clearly about health, women's health, medical procedures, that seems to skirt around the idea of actually coming to any sort of scientific consensus, actually delving into the science of the issue at hand?
Well, I mean, I totally take what you're saying. I don't think the court necessarily had to get into science. What it totally failed to recognize as, let's say, medicine. Alito 5 or 6 times uses the word abortionist to describe providers of abortion care, right? That's a kind of a slur, and is designed to stigmatize and carve abortion care out of basic health care for women, right? We know that some 35–40% of all American women will have an abortion during their reproductive lifetimes. The ability to control their reproductive lives is essential to the way that women live in modern society. So not so much the science of fetal development. I didn't expect to see it there. I don't want these justices to be opining on the science of fetal development, but the failure to recognize that we're just talking about basic medicine, medical practice, was a little bit astonishing.
And because of the lack of understanding of medical practice, it does seem to open up so many other potential issues that will come back to the court. And in this piece, Linda, you essentially say, look, this is not the last the court will be hearing of this, because just off the top of my head, I was thinking about cases of rape and incest and of child pregnancies that I'm sure will be coming back up in American life and perhaps coming back to the court, but also issues of in vitro fertilization, of the very drugs that women use if they are miscarrying. These are all things that are put in specific jeopardy right now because of this ruling, and many of them have nothing to do with the sort of abortion that Sam Alito, I think, thinks he was writing about.
Oh, absolutely. I mean, the whole question of in vitro fertilization is very much front and center now, because states that declare that a fertilized egg is a person within the meaning of the state's criminal law. Well, of course, in vitro fertilization involves fertilizing eggs and implanting them and having embryos basically left over. And the consequences of the notion that each little fertilized egg has the moral weight of, you and me, people can think that it's a religious belief, but we've got to label it as a religious belief. And that's what infuses the Supreme Court's opinion. In fact, Alito takes pains to say, well, we're talking about abortion, we're not talking about birth control, we're not talking about, all these other personal rights that come under the flag of substantive due process. Abortion's different, he says, because it involves potential life. What he doesn't acknowledge is that's his religious belief. That's not everybody's belief. Obviously, it's potential life in the fact that if undisturbed and unmiscarried, in many, many pregnancies, miscarry sometime, many before a woman even realizes that she's pregnant. So yes, potential, everything's potential. But to assign moral weight to that, these 5 justices, by saying abortion is different because of that, they're saying because that's what we believe. And our belief is now projected across the face of the US Constitution.
But it's also not entirely clear that, for instance, the issue of contraceptives as a legal right is settled.
Clarence Thomas, in his concurring opinion, tells us it's all up for grabs. Absolutely.
It's all up for grabs, and other things potentially are up for grabs too. And I want to get to some questions in the Q&A function that people have specifically about this Dobbs decision. But Clarence Thomas essentially seems to open up the possibility of coming after other rights like same-sex marriage, something that has been enshrined for not that terribly long.
Yeah, I have a few things to say about that. So, it's nothing new for Clarence Thomas to say everything's up for grabs because he thinks everything is up for grabs. He's never accorded any weight to precedent. And he basically thinks that the Constitution went wrong in the 20th century. And his mission is to, call it out and get it back. I actually cannot imagine that the court would flatly overturn Obergefell, which is the 2015 decision that constitutionalized the right to same-sex marriage. But what the court is going to do, and is in the process of doing, is carving out as big a kind of carving a tunnel through that right for religious individuals who don't accept the decision and who believe that legitimate marriage is only between a man and a woman. And so giving business owners and other types of people who interact with the public the right to say, no, we're not going to deal with you. The court has taken such a case for the new term, a case called 303 Creative, which is brought by a woman web designer who doesn't want to have to treat everybody who comes to her business with equality. So she doesn't want to have to create a wedding website for a same-sex couple, and she wants the right to announce this discriminatory policy on her website, which is in violation of the law, the anti-discrimination law of the state where she lives, which is Colorado. And the court accepted her case, even though she's not yet in the business and she doesn't have any customers. It's an abstract proposition, but she claims I'm a Christian and I can't put up with same-sex marriage. The court is going to hear that case, and that tells us that as many as many exceptions to the notion of equality with respect to LGBTQ people, that's what's up for grabs.
We do have a bunch of questions, and some of them, many of them actually have to do with what states are now required to do at this point. Shira had written in, she says, now that SCOTUS has taken away our constitutional right to abortion, residents across the country have now been set to task to build protections for state-level abortion access. In Connecticut, how much of a priority, she asks, is it to enshrine our right to abortion access in our state constitution? What are the chances of residents losing even more access to abortion care? So she's talking specifically about Connecticut, but I'm sure that this very much applies in some of the other states where people are joining us tonight.
So Connecticut has been great on this. The Connecticut legislature has really been at the front lines of protecting the right in the state, and announcing, as I understand it, I mean, don't rely on me, but my understanding is that there's language that would protect women, what I call abortion refugees, from states where abortion has been criminalized, are already coming to Connecticut, especially if they have, family here or some action state. They are coming, and providers. There's a lot that's up in the air because some of these criminalizing states claim the right basically to chase through legal process women and providers in other states. And, we have such a thing as the right to travel in the Constitution, or so we think. But the word travel is not in the Constitution, just like the word abortion is not in the Constitution. And somebody's got to test this really quickly and see whether Brett Kavanaugh, who said in his concurring opinion, oh, don't worry, we're not going to have a regime of people being chased around from red state to blue state, whether there are 5 votes for that guarantee. So far, I only count, him. So that I know in the provider community, there's a huge amount of fear. For instance, Planned Parenthood in Montana has taken where, as I understand it, abortion is in the state constitution. So Montana is a legal state surrounded by criminalizing states. And they're saying, we will not prescribe the abortion pill for women from criminalized states. Why not? Because they would come to Planned Parenthood in Montana, they would get the 2 pills, they would take the first one there in the clinic, they would go home and take the second one in a state where that's illegal, and the providers are desperately afraid. So we need a test case. We need somebody brave enough to bring a test case. And I'll just digress for a minute. I mean, here in Connecticut, so people may know Griswold against Connecticut, 1965, that was the case that established the constitutional right to birth control. So that the Connecticut birth control prohibition had been challenged previously, before 1965, but the Supreme Court had thrown the case out because there was no prosecution, there was no standing, the case wasn't ripe. So Estelle Griswold, who herself was not a doctor, she was the director of Planned Parenthood, the clinic in New Haven, had the clinic dispensing the pill, and said, basically, come and get me. And they did. They came and got her, and that gave a concrete case that went up to the Supreme Court and established the right. So we need to see something like that. It's easy for me to say sitting here in my little study, but we've just got to figure out what kind of protection there's going to be for providers and for refugees.
Yeah, and to that point, I mean, some questions getting Steve writes, are we likely to see civil disobedience to court decisions like the way Americans disregarded prohibition? Matthew writes, Linda said there's no one who can stop the radical majority in the court, but given that the court depends on voluntary acceptance of its power, they have no power to act, only to speak. Could people just ignore them and thus gut the authority that the court relies on? That sort of gets to your earlier point. If people just say, we're just not going to pay attention to whatever you say the law is, what does it mean?
Well, to be clear at the threshold there, so the court has said there's no constitutional right to abortion. That doesn't mean abortion is prohibited. So that's up to the individual states. And we know that in half the states, abortion is going to be prohibited. So those states, those governors and attorneys general and prosecutors, they're going to, come out with guns blazing and prosecute. These are their laws. And so, and in the other states, in the Connecticuts of the world, protection remains. And so I understand that question. It's not quite pertinent because it's not that somebody in one of the criminalizing states would say, I'm going to defy the Supreme Court. There's law on the books that they would be defying, the state law and they'll be putting themselves in great jeopardy.
We got another call here from Frank, who asks, can you comment on the Florida Jewish rabbis lawsuit on the basis of the recent abortion decision and how it can conflict with Jewish belief that life only begins at birth?
Yeah, it's interesting. So there was a congregation in Florida has sued the state of Florida for its anti-abortion legislation, claiming that as a matter of free exercise, the free exercise clause of the First Amendment, which the current Supreme Court has beefed up enormously for Christians, that Jews have a constitutional right to act on their own belief that life worthy of protection begins at some point. Some say birth, but certainly not at fertilization. And, I'm not sure that lawsuit is actually going to go anywhere, but I think it's very instructive and useful to realize it underscores the fact that there's one religious belief that has underscored and in my opinion, created the anti-abortion regime that the Supreme Court has propagated. Only one in this very diverse country. And we ought to keep that in mind as we proceed to talk about this.
Barbara writes, the First Amendment secures the separation of church and state. However, it seems the court is moving to blur this line. How can this be stopped?
Well, absolutely, the court is blurring this line. So maybe we should broaden the frame here. The court had two very important religion cases in this last term. I mean, I regard the abortion decision as a religion case, but that's just my view. And in both of these cases, one of which involved channeling public money to pay for parochial school tuition, the case from Maine, and the other that got a little more press than that is the coach who was given the right to pray on the 50-yard line after a game at a public high school. So in both of these cases, what the court relied on was the free exercise clause of the First Amendment, which is one of two religion clauses. The other is the Establishment Clause. And it's the Establishment Clause that really supports the separation of church and state. Congress shall make no law that establishes religion or prohibits the free exercise thereof. And the court has basically written the Establishment Clause out of First Amendment jurisprudence and is relying entirely on the free exercise clause. Now, ask yourself, had Coach Kennedy, the praying coach, been, for instance, a Muslim who went out to the 50-yard line and laid down a prayer rug and started praying to Allah, would the Supreme Court have ruled the same way? Just a question, just a curious person wants to know.
I want to encourage people who are listening and watching to get your questions to Linda using the Q&A function. We'll get to a bunch of them throughout the course of the rest of our program, which is going very fast for the next half hour or so. In the piece that we were talking about, Linda, that you wrote, the Requiem for the Supreme Court, you cited and linked to your own reporting on the issue of abortion rights from back in 1970, perhaps one of the first times that this was written about at all in the New York Times. And I want to read a little bit about what you wrote. You said, a right to abortion. Such a notion at first hearing sounds fantastic, illusory. The Constitution is searched in vain for any mention of it. The very phrase rings of the rhetoric of a women's liberation meeting. It's a very, the whole piece, I really encourage people to read through because it's a very interesting glimpse into the time period. Could you just take us back to then, to 1970, and the question of abortion in American life before it got to the court?
Yes. So before Roe, abortion was criminalized in almost every state. At the time that I wrote that piece, I have to say I was a baby reporter. I mean, maybe old, but I'm not quite that old. It was the first major piece I ever wrote for the Times, actually. At that time, the New York legislature had just rejected an effort to decriminalize abortion by legislation. there was a movement in the country to do that, but it was floundering, and that's why people were turning to the courts. Right, very soon after that piece appeared in 1971, the New York legislature, by a single vote, actually decriminalized abortion, and created a huge ruckus. And the Catholic Church kind of rose up, and the bishops demanded that the legislature repeal the repeal of the criminal abortion law, and the legislature did. The legislature crumped the next year, and only the veto by Governor Nelson Rockefeller kept New York in the decriminalized column. So I went into that kind of detail to say that there are a lot of people, and unfortunately, the late Justice Ruth Bader Ginsburg was one of them, and she was not correct, that, oh, if only the court had stayed its hand or ruled in a less sweeping way, there was reform that was rolling across the country. Not true. Not true, because the church had gotten energized and was fighting very hard against referendums in Michigan and other states. And so there was a kind of I think what political scientists would call a legislative lockup. The call for reform, I mean, I say in that piece, the women's liberation, that was the language of the times, as you point out. The actual early calls for reform that led up to the 1970 ferment that I was writing about came actually not from women, but from doctors, and especially from public health doctors. A woman named Mary Calderon was a very well-known public health doctor, and she wrote an article, appeared, I think, 1969 in a professional journal, that was entitled Abortion as a Public Health Crisis, because there were upwards of 500,000, maybe 1 million illegal abortions a year in the country, with very damaging consequences for women's health and even for their future fertility or for their lives. And so as the medical profession said, this doesn't make sense. Women are having abortions, there will be abortions, and we might as well decriminalize and bring it within basic healthcare, and that was the early impetus, and people aren't too aware of that, I think.
And I think it gets, though, back to the question I asked earlier about how justices throughout the course of your career, but then also justices right now, actually have considered the science of the issue, the what doctors and nurses and public health professionals are saying. Abortion is healthcare in America. It just is. That's not up for debate. And so what seems to be happening is them determining that it's not, that it's just not healthcare anymore for people. And that is making essentially a scientific declaration. They're essentially saying the science is wrong. Doctors aren't right. This is something that's different than women's health.
That's a very strong point, John. And it really bears emphasizing, because we know that that's not right. And there's currently about 1 million abortions a year, and in this country, maybe 900,000 legal, safe. And I'm here to say there's going to be hundreds of thousands of abortions, maybe not legal and not safe going on. So the court has backed us all into a very retrograde corner here.
There's a sort of a foundational question that David asks here. Are there any other decisions in which the court has taken away a constitutional right previously recognized by an earlier decision?
The short answer is no. The longer answer is depends how you look at it. Yes, the court has taken away some, believe it or not, corporate rights over time. They've never taken away an individual right, that certainly one that goes to the ability of individuals to be full participants in civil society. That's what this is about. And no, it's never happened before.
We have a question from Emma here. Thank you for this discussion. I'm a young woman currently pursuing my MPH and studying public health law. Do you have any advice for overwhelmed students of law? What can we do individually? What can we ask of our government? Thank you. It's a good question.
Yeah, if I had known there was such a thing as public health as a field, I really might have gone into it when I was in college. And so I congratulate you. What can people do? I mean, advocate, vote. At Yale Law School, where I teach, there's an entity called the Solomon Center, which is a joint venture between Yale Law School and the Yale School of Public Health that brings together scholars in both disciplines to really just get knowledge out there. So I think anybody in public health has to be almost a public servant and certainly a public spokesperson for evidence-based medicine. And I think that's part of the training these days, and it's certainly essential in this moment to have people like that.
We're getting more questions, of course, about the abortion decision, but there are other cases. You've already referenced a few religion cases. Mary and a few other folks would like your comment on the EPA decision and the future of the administrative state. Of course, this is a ruling that when I talked at the top, Linda, about never seeing a court term like this that dealt with so many of the most pressing issues of our time, right? We've been hearing about what the court is going to do about abortion for decades. The court also took on guns, which we'll talk about in a second, but the court also weighed in on the EPA's ability essentially to control the gases that cause climate change, which is probably our biggest existential threat on the planet. And this is also a consequential decision that's perhaps a bit lost in everything else that happened.
Yeah, I mean, it's a decision that kind of exists at the interface between the Constitution and statutory interpretation. So at the kind of simplest level, it was an interpretation by the court of the statutory framework of the Clean Air Act to be administered by the EPA. It's been an accident waiting to happen for quite a while, although a lot of it's been kind of beneath the radar. But this was an exceedingly activist decision. Why do I say that? It's because the Biden administration had yet to actually issue a rule. So the court reached out and invalidated the EPA's ability to kind of write broadly, dealing with coal-fired plants and alternative energy sources and so on, to write broadly before it actually had a target in the sense of there's no rule, the rulemaking is ongoing. So it was, the court wanted a case like this to put out this major question theory, and basically turns the issue over to Congress. And of course, we see in Congress, I just read in the paper today, that Senator Joe Manchin, Democrat of West Virginia, says he's not all in for incentives for electronic vehicles, for electric cars. And of course, the reason is that the people who give him money are the fossil fuel people from West Virginia. So we've got another legislative lockup. The court decision doesn't in any way hamper Congress from saying, here's the policy and here's what we want the EPA to do. But the court ruled in the knowledge that Congress doesn't have the ability right now to do that.
But isn't the nature of the regulatory agency in America that it is acting as part of the executive branch, that it is acting not with the oversight of Congress for every single decision it makes? I mean, how broad potentially is this beyond this EPA ruling and what it means for environmental protection, what it means for clean air? What does this mean for regulatory agencies writ large?
Yeah, we'll see. I mean, I think what it means is if a regulatory agency does something that gives a majority of the current Supreme Court some policy concern, they're going to say, "Oh, that's a major question."
I'm sorry to laugh, but I mean, again, not being a constitutional scholar, Linda, I was like, that's not the court's job, is it?
Yeah, right. I mean, the court's job is to police the boundaries between, among the branches, and we get that. But they've launched this major question doctrine without, excuse me, without really defining it or telling us what is a major question, other than it's what five of us don't like that an agency did. I hate to sound so, flip or cynical, but there's nothing in that opinion that really gives us anything to hold on to predict what happens for the next case and the one after that, except that we know that the court is going to put the agencies on a very short leash, and what the court says is how their power is going to be constrained.
Of course, on the flip side, I will say that I think many people in America might say that some regulatory agencies and some regulatory decisions don't act in the best interest of the large majority of Americans. And mightn't it be a good thing for the court to weigh in this way, seeing as how Congress probably isn't going to do anything about it, right? It's not like these decisions all just necessarily flow one direction. Regulatory agencies during the Trump administration did an awful lot of things the Democrats didn't like too.
Well, of course, that's true. I mean, it's very complicated government, and the court has had. Excuse me, I'm going to mute myself so I can.
Yeah, sir, absolutely. And I'll tell you what, I'll let you take a drink of water and mute yourself and cough for a second. Just say, I am seeing a number of questions come through in the chat field, and if you want to get them to Q&A, make sure you put them in the Q&A field, and I'll try to see as many of them as I can in the last 15 minutes, because there are a few queued up, as it were. And we want to get some more questions. If you are watching our event from one of the other states that has joined us, Pennsylvania, Mississippi, New Jersey, Vermont, please feel free to let us know that you're writing from one of these other places, because we'd like to get some of your questions in there as well. Linda, how are you doing? Good?
Yeah, I'm not used to talking so much these days. So what I was going to say was the court for several decades has had something called the Chevron Doctrine. People may have heard about this. It makes a great deal of sense. And what it says is that if the agency's interpretation of its power is plausible, then we, the judiciary, defer to the way the agency deploys its power. It makes a lot of sense. And so, that gives the court the running room to look at the underlying statute and say to the agency, hey, you're off in the woods here. But this major question thing is kind of an overlay on that seems to give the court has helped itself to power to go beyond that kind of foundational determination. Is the agency acting within the authority that Congress gave it to say, do we like or do we not like what the agency is actually doing?
I mentioned, of course, the third of these major issues that's at the heart of American life right now, guns and gun rights. Another consequential 6-3 decision struck down a New York gun law, essentially making it clear that Americans have the right to carry firearms in public for self-defense. Can you tell us a little bit about what you saw in this ruling, and maybe did you see this coming for a while?
Oh, yeah. So it had been, I guess, 14 years since the Heller decision in 2008. The court had not, that's the case in which the court for the first time interpreted the Second Amendment to convey an individual right to what? Heller was to keep a handgun at home for self-defense. So there have been many efforts since then to get the court to broaden Heller. The gun lobby was quite dissatisfied with Heller, didn't go far enough. And so we had several justices, Justice Thomas, Justice Alito, complaining, oh, the Second Amendment has become a second-class right because we're not taking any of these cases. So in the spring of last year, 2021, the term that I wrote my book, Justice on the Brink, about, I talk about the court finally taking a gun case. And once they agreed to take it, the outcome was totally predictable. I mean, the key decision point in that case was taking the case, taking the NRA back challenge to the New York gun licensing law, a law that was shared by maybe half a dozen other states. So, you know, what Justice Thomas, of course, wrote that opinion, said was, well, we look at history. I mean, it makes very little sense because in history, of course, in the framing generation, people were walking around with muskets, you know, not with the kind of weaponry that we have today, but we'll leave that aside. It was a case with a foreordained conclusion. And so what's kind of interesting right now is what happens next. And so the New York legislature immediately kind of took the majority up on what it offered, because what it offered in that case was, well, of course, we don't mean that someone has a right to walk around with a concealed weapon anywhere. There are sensitive areas where they can't. So the New York legislature passed a post-SCOTUS law identifying a big bunch of areas that are deemed sensitive. And of course, yesterday, two individuals backed by the gun lobby filed federal district court lawsuits challenging those restrictions. And so in no way are we done with this. You know, and the week that the court accepted the case back in the spring of 2021, I think there had been 2 major gun massacres in the prior week, and that did not cause them to stay their hand. So here we are.
Yeah, and the ruling comes down, yeah, in the midst of more gun massacres. There are, in America, there are limits on what type of weaponry you can carry, when, and where. I guess the larger question is, when you say that this isn't over by a long shot, does this mean that the possibility of more rights to carry more types of weapons in more places will be given across the country?
Well, it depends on what there's 5 votes for, you know. And does Congress have any willingness to go beyond what it did and you know, reinstate the ban on, what was it, on machine guns and different kinds of, you know, major small arms that existed for about 10 years and then was allowed to expire about 10 years ago. And I've seen data that suggests that during the time when it was in effect, there actually were fewer of these mass shootings. You know, does the court hear this? Is the court interested in knowing about this? I don't know.
Let's see. We have some other questions here I wanted to get to. I also have to ask you a question, and it's less of a question. I'm just going to throw out a name and I'm going to say discuss. So Linda Greenhouse, Ginny Thomas. Could you just talk about Ginny Thomas? The idea of a wife of a Supreme Court justice who's so clearly involved in politics. I've asked you a number of times, have you ever seen anything particularly like this? I'm just wondering if you have any analogs from your past coverage. Is there anything that you've seen like this? And what happens, do you think, with the wife of Clarence Thomas?
I've never seen anything like it. It's pretty astonishing. And I think nothing happens.
You think nothing happens?
Who's going to make anything happen?
And there's no precedent for anything like this for anybody to point to.
No, there's not. You know, she hasn't broken any laws. I mean, I don't see any way to, you know, curb her her instincts or her behavior.
Has there ever, though, been a question of somebody close to a Supreme Court justice who potentially poses a conflict of interest in issues that are going to come before the court? It seems fairly clear that something coming out of, say, the January 6th hearings may very well appear in front of the Supreme Court of the United States at some point while Clarence Thomas is there.
Yeah, then it's up to Justice Thomas to decide what to do about it. But you asked me about Ginny, and she's a free agent.
That's fair enough, and a good and I think exactly the right answer. Mary asks, is there any hope for a nonpartisan Supreme Court in the future, or has it just become another political entity?
Well, I have a baby granddaughter, and I have told my daughter that it's going to be up to baby Lizzie's generation to fix this. Nothing's going to change very soon. I think, obviously a lot of this resides with the confirmation process and the power game that's played on Capitol Hill and the relationship between the president and the Senate at any point in time. But I think we've gone pretty far down the road, certainly with the last three appointments. The first, of course, Neil Gorsuch sitting in the seat that should have gone to Merrick Garland when President Obama was in office. I don't see a way of climbing out of the hole that we're in, actually.
One thing that many people on the progressive side of the Democratic Party have suggested, and there have been some pieces of legislation put forward to this effect, is that while the Democratic Party has a majority, that they should attempt to expand the Supreme Court. I think you and I have talked about this before. I guess I'm wondering about that. Is that possible? How would it work if it were to happen?
Well, I don't think it's politically possible. There's not a majority. There's not a filibuster-proof majority in the Senate, or I think not necessarily a majority in the House to do it. It's within Congress's power. The Constitution leaves it completely up to Congress to set the number of justices. So there's no, theoretical objection to it. Is it a good idea? Not necessarily, because it just becomes a kind of an arms race. And, if there were a political moment when one party held two houses of Congress and the White House, and they wanted to add justices, and the pendulum swings the other way, and the next party.
But isn't it already an arms race? I mean, it seems as though that's the point. And we've already gotten to the point at which the most important thing, perhaps, that a new administration can do, certainly if it has the support of the Senate, is to seat Supreme Court justices. And so in some ways, it's become a political arms race already.
Well, that's true. We're not going to have to deal with it because it's not going to happen. But I think one objection to it, if you were that nominee for whom a new seat had been created so that you would cancel out the quote stolen seat or whatever, you'd really be in the spotlight. You'd really have a lot of water to carry for those who brung you to the dance. And I don't know, it makes me a little uneasy, the thought of it. But I respect people some very smart people are persuaded that this is the way to go. So I don't argue with them. It just has never struck me as really any kind of answer.
And as you say, not politically possible, certainly at the moment. Henry writes, could you comment on the obligation, if any, for the court to respect the majority opinions of the people?
Well, that's a tricky question because, of course, when those times when the court has stood up for minority rights, we have tended to applaud that, where the court hasn't just sort of followed majority will. So I think it's a nuance. It's got to be a nuanced answer to a question like that. Should the court be aware in kind of general sense of where the public is, yes. I think for the kind of stability of the system, if not just for the institutional welfare of the Supreme Court, and I think their court's in very tricky territory right now. But do we want them just to kind of put their finger in the wind and, take their own polls and do what a majority of people seem to want them to do? I would kind of hope not. I mean, I look back, not that many years, well, I guess it's 20 years now after 9/11. Certainly a majority of the public at that time, I think, would have basically looked at the prison in Guantanamo and said, yeah, whatever, go right ahead. And it was the conservative Supreme Court that put some brakes on that and accorded some constitutional rights to the men who were being held there. And, I kind of cling to that in my mind as something that I witnessed at very close range, where I thought the court really stood up for the best of American society, even though American society had you taken a poll at that time would have said, forget those guys.
But that's not that long ago. We can remember it pretty clearly. And as much as it seems in this moment that we could, as you write, Linda, write a requiem for the Supreme Court, is there a way that we get back to that? I mean, is it just so purely partisan right now that we can't imagine a Supreme Court that can act in such a way?
Well, looking at, this last term and looking ahead to the next one, which promises even more disruption of our voting process and so on. I wish I could say, oh yeah, it's all going to be okay, but I have great concerns about it.
We had a couple people asking before we run out of time, what are the major cases that they're going to be taking up next term?
Well, there's two major voting rights cases. One really goes to the constitutionality of what's left of the Voting Rights Act of 1965. That's a case from Alabama. And then there's people may have heard about this independent state legislature case from North Carolina, which goes to the question of whether state Supreme Courts have any role in setting the rules for the conduct of elections, or whether it's just up to the legislature. Very important case. So, I mean, there are a bunch of other big cases too, but I think we're out of time, and I just urge people to pay attention to those as we come up to the next election cycle.
Linda Greenhouse, it's always great to talk with you. Thank you so much for your insight and for answering all these questions from me and from all the folks at the Mirror and from around the country. I really appreciate it. It's good to see you.
Good to see you. Thanks for having me on.
I want to thank everyone who joined us, not just from the Connecticut Mirror, but also from Spotlight PA, Mississippi Today, New Jersey Spotlight, and Vermont Digger. All of these organizations are growing, and they're trying to give you more news that you need about your state, where you live, and some of the important issues that face America right now. Please consider supporting nonprofit, independent journalism wherever it is. If you want to support the Connecticut Mirror, it's very simple. You go to ctmirror.org. You can click on the big red button at the top of the page. You're not just supporting the work that we're doing right now, but you're supporting the growth of the Mirror. As we said at the top, we've been hiring a lot of new reporters. We're hiring new editors. We're trying to do an awful lot of things that haven't been done in Connecticut media and for quite some time. And so if you do want to support us, again, it's connecticutmirror.org. Click on that donate button and you'll help Connecticut Mirror to grow. Thanks so much to our publisher, Bruce Putterman, to Kyle Constable, who produced this and all of our events, and to our executive editor, Beth Hamilton. Thank you so much. Have a great evening.